Good morning to everyone joining us from all across Asia, and welcome to Finnegan's webcast, Obviousness, How to Prove and How to Attack. I'm Gary Ma, Resident Managing Partner of Finnegan's Taipei, Taiwan office, and I'll be your moderator today. It's my pleasure to welcome our presenters, Adriana Berge and Tony Gutowski. Adriana is a partner based in our Washington, D.C. office and leads our patent office practice. Her practice focuses on opinion work, client counseling, patent prosecution and management, and litigation, particularly in the chemical, pharmaceutical, and biotechnology arts. Adriana has managed the prosecution of hundreds of patent applications domestically and internationally, guided and advised clients on complex procedural and legal issues surrounding their patent portfolios, developed and implemented strategic prosecution in support of ongoing litigation, generated strategies for maximizing investment in patent portfolios, and facilitated the identification of high-priority applications within patent portfolios. Tony is a partner based in our Reston, Virginia office, and he heads our mechanical practice group. Tony's practice focuses on client counseling, patent procurement, and patent enforcement. Tony has prepared and prosecuted several hundred patent applications to patent issuance in the United States as well as outside the United States. He also has vast experience in complex U.S. Patent and Trademark Office proceedings such as IPRs, interferences, appeals, reissues, and reexaminations. Tony frequently represents clients in the automotive, mechanical device, construction equipment, sporting goods, electronics, and consumer products industries, where solid patent positions form a critical foundation for meeting business goals. Before I turn things over to our presenters, I invite everyone to participate by submitting questions. Just click on the red Q&A button at the lower center of the webcast interface and type your question into the Q&A window, then click Submit. We will get to as many questions as we can during the question and answer session, which will take place at the conclusion of the presentation. You may enlarge the slide window at any time by clicking on the green Enlarge Window button on the top right side of the slide window. The slides will advance automatically throughout the event. If you are experiencing any technical difficulties, please click on the yellow Webcast Help Guide button in the lower center of the webcast interface. I also want to take this opportunity to remind everyone that our next program in the series will be held on May 9th, when we will present Choosing and Challenging Venue, District Court and ITC. To register, please click on the webcast link in the resources list. And now, I will turn it over to Adriana and Tony to begin our presentation. Obviousness, How to Prove and How to Attack.
Thank you, Gary, for that introduction. We're going to begin our webinar with briefly going over the topics we'll cover. Today, we're going to start off with what is a prima facie case of obviousness? I think I've seen in some of the questions people have submitted before the webinar and actually just right before the webinar. This seems to be a burning question that people are looking for some answers on. Next up, we'll address what are some of the ways to defend against an obviousness challenge. And after a prima facie case is established, how can you rebut a prima facie case by looking at secondary considerations? Next up, what roles do unpredictability and unexpectedness play, especially with regard to particular technologies? I think we'll probably touch on the mechanical and electrical side as well as the chem, pharma, biotech side. And finally, we'll round out the webinar with when and where to use declarations. So with that, let's get started. What is a prima facie case of obviousness? And before we start discussing exactly what a prima facie case of obviousness is, it's probably instructive to take a look at the statute itself and to see exactly what it says. The obviousness statute in the U.S. is found under 35 U.S.C. Section 103, and we have here on the slide both before and after the America Invents Act, AIA. So the old, which is pre-AIA, was under the regime of our regime of first to invent. And so here, the 103 statute basically said you cannot obtain a patent on the subject matter as a whole that would have been obvious at the time the invention was made to a person having ordinary skill in the art. So again, we were pre-AIA, first to invent, at the time the invention was made. And then you contrast that with post-AIA, where the U.S. was seeking to harmonize with all the other countries in the world, to a first inventor to file, the 103 statute changed, and here we see that you cannot obtain a patent on a claimed invention as a whole that would have been obvious before the effective filing date of the claimed invention to a person having ordinary skill in the art to which the claimed invention pertains. So here the slide was just meant to give you both views, pre-AIA under the old view and then post-AIA where we're in first inventor to file. And next up, again, looking at those two different statutes, when you're looking at obviousness, you need to make sure that you're applying the correct law. And here, the first scenario is you have a PCT filing before March 16th, 2013, which is when AIA went into effect with respect to these statutes. So here you're under the pre-AIA Section 103 obviousness statute. And then if you look at the bottom scenario where we have the effective date, we have the priority date as well as the PCT filing date after that March 16th, 2013 date, the post-AIA Section 103 applies. And then that middle scenario where you're straddling those dates, you have a priority date before March 16th, 2013, but your PCT filing date is after. There's essentially three different scenarios. So in one instance, you have no claims that are entitled to the priority date. So you're really relying on that PCT filing date, which is after March 16th, 2013. So again, you would be under AIA. The next scenario where all the claims are entitled to that priority date, so before the March 16th, 2013 date, you would be under pre-103. And then that last scenario where you have a mixed, where you have claims that straddle both the priority date you have support for as well as after the filing date. And because you have a claim that straddles that date, under the PCT filing date after the March 16th date, you would fall under the AIA Section 103 would apply to all the claims.
And I think it's important to note for purposes of this exercise that the prior art implications of AIA will control, and of course our AIA statute changed the definition of prior art. That will of course impact obviousness, and it's an important threshold question to determine which regime you're in, whether you're in the first to invent under our prior law or our first to file. And the implications sometimes can be, the outcome can sometimes be the same, but in some instances, especially when there's close prior art issues, you really have to study this, and that can really be determinative as to whether or not there is a prima facie case of obviousness.
Yeah, absolutely, Tony. And, the other thing to consider is, from a prosecution perspective, when you get your office action, the office is now identifying, I think, usually as paragraph number 1, whether this is a pre-AIA case or a post-AIA case. So it's really, as Tony just pointed out, you really do need to see where you're falling to make sure that the office is applying the correct law.
And we've seen quite a bit of confusion among examiners, as you might imagine, and they're oftentimes very confused and many times get it wrong.
Yes, that's true. So next up, what we're going to talk about is really the framework for the objective analysis for determining obviousness under Section 103. And that really comes from this Graham versus John Deere case, the Supreme Court case that occurred in 1966. Still good law today. Examiners still use it, not only examiners, but if you're challenging the validity of a granted patent in court, it's still, these are still inquiries that you need to make to establish that prima facie case of obviousness. And really, here, the Graham versus John Deere case really sets out that obviousness is a question of law. based on underlying factual inquiries, and those factual inquiries are, these three that are articulated here. Number one, you need to look at the scope and content of the prior art. Number two, what are the differences between the prior art and the claims at issue? And number three, you need to figure out what that level of ordinary skill in the art is directed to those claims. And so, we have them articulated as 1, 2, 3, but invariably, they may come out of sequence. But these are the factors that an examiner looks at when they're doing your office action. In certain examiners, I see actually articulate this. These are the headers of the paragraphs when they're establishing their 103 rejection. They're going through this. This is kind of the rubric that they're looking at to establish, their obviousness case against the claimed invention.
Oftentimes that third factor can really come into play to bite one way or the other. In other words, the level of ordinary skill in the art, if the level of skill is very high, if, for example, the ordinary skilled person is, for example, maybe a PhD scientist with an extensive amount of research knowledge, the obviousness in a circumstance like that might be very extensive. In contrast, if the level of skill is very low, maybe the step for inventiveness is a slightly less leap or a slightly lower leap, and that can oftentimes come into play in this analysis.
Yeah, agreed. And I think, the last bullet point here, too, is, such secondary considerations such as commercial success, long-felt need, et cetera, those also come into play, and we'll touch more later on in the presentation. But, it's interesting that this Supreme Court case in 1966 still remains good law and really is, the rubric in which the 103 obviousness is established. And we did have in 2007 KSR, which came out, and I think from my perspective at least, it kind of sent shockwaves through the patent bar, and I think even today we feel its ramifications on obviousness, and not that it challenged or changed the Graham factors, those three factors that we just spoke of. It really reaffirmed it, but really what it did is it took a look at and addressed kind of that motivation to combine. So even though you're looking at all three of those factors, there's still this aspect of establishing an obviousness case where you're looking at how you resolve all those factors, and where does a person of ordinary skill in the art find the motivation to put all these little elements together, these claim elements together? And so what we found was that the Supreme Court found was that the Federal Circuit applied an overly rigid, almost a formalistic test that this teaching suggestion or motivation, that you had to have it there. And the Supreme Court came back to say, look, you need to have a flexible approach and granting a patent based on the combination of different elements that are already found in the art. And I know, at least from my practice, I'm more chem, pharmaceutical, biotech. This had an impact on us because I can remember arguing that there was no teaching suggestion or motivation at all. There was nothing that the examiner was pointing to. And it almost felt like the examiners were reinvigorated after KSR and really, I think almost took it to the extreme that they weren't necessarily identifying or articulating some motivation that they found in the art to put all of my different elements together for obviousness. I don't know, Tony, how did it come out in the mechanical electrical area?
Quite similarly, Adriana. In fact, it was a dramatic pendulum swing because just prior to KSR, there was a real push at the Patent Office, and they were training examiners to, in fact, encouraging them to issue patents and telling them, this is the Patent Office, this is not the Rejection Office. KSR was a seminal case because prior to that, the Federal Circuit had implemented the teaching suggestion motivation test. It's really a test that was implemented to try to deflect and to try to take away from hindsight bias that can sometimes be implicit in obviousness rejections, and it was comfortable. It was a very easy test to apply, this teaching, suggestion, motivation. Unfortunately, though, the Supreme Court disagreed. They looked back to the Graham test. They said, you've got to look at that Graham test. And when you look at the statistics, it's really dramatic because, in fact, if you're ever analyzing validity of a patent, if you look at a patent that issued prior to KSR, you really want to really look at the prior art real closely, see if you can come up with a potential obviousness argument. And just when you look at the number of patents that were granted, after KSR, the number went down pretty dramatically. Now I think we've settled out a little bit because everyone is a little bit more comfortable with the parameters of obviousness. But as we'll talk about a little bit later, it's really made a significant impact, I believe, in some of the technologies that are often labeled as more predictable technologies. And it can sometimes be a real uphill battle to establish non-obviousness.
Yeah, agreed. So from KSR, we have this quote that I think is kind of the glue that kind of holds those 3 Graham factors together, that even though you've looked at those 3 factors, you still need some articulated reasoning with some rational underpinning why you're putting these references together, why you're combining these elements. And so, when you look at that, where you still need that some reasoning, albeit it's not, this rigid approach that it has to be expressly found in the prior art references, but you still need to have kind of, I want to say, this link or this glue that holds those things together. And what we really found is that, in the case law, it's now also recited in the MPEP, there's these different ways, these different rationales that examiners can use, as well as challengers challenging a granted patent, as to why you would put these elements together. And on this slide, we have them articulated. And really, again, this is that link between the factual findings and the legal conclusion of obviousness. So maybe, for example, you would combine prior art elements according to known methods, and you obtain a predictable result. There's case law that support that is a proper rationale as to why somebody would put these different elements together. The same thing, maybe it's a simple substitution, a known technique, a known device, maybe it's obvious to try, known work in a field that you can use in a different field, and then the last one, some teaching, suggestion, or motivation.
And it's interesting because that teaching, suggestion, motivation is still one of those factors that is applicable, but among other factors. And this is one of those places actually in the MPEP where it's extremely helpful. They actually did a decent job of summarizing the law, and this is a good place to look. As Adriana had mentioned, this is applicable not only to ex parte prosecution in patent applications, but also when you're challenging validity. If you're challenging patents at the Patent Trial and Appeal Board in an IPR, for example, inter-party review, or if you're challenging them in district court or the ITC. And what's quite striking, as I had mentioned before, this predictability issue or predictable technologies, look at all these different tests and look where we have in bold this term predictable and how that comes into play and how important that is. And I think also that quote that we had previously looking at the KSR decision, how there's this requirement to have an articulated reasoning with some rational underpinning. It is really something that is necessary. If you don't have any analysis, if someone just in a conclusory fashion comes out and says that something is obvious, clearly you can challenge that. You've got to have some analysis. There's got to be some, what we sometimes call in the U.S., meat on the bone, so to speak.
Mm-hmm. Yeah. And, this is, whether you're looking at, a patent examiner's office action or whether you're looking at at a petition challenging the granted patent, a lot of times this is what you're looking for. You're trying to figure out in their argument, how are they doing this? Are they really just making a simple substitution of things? Are they really articulating an obvious to try? Look, it would be obvious when you look at the state of the art and what's out there. A lot of times that tends to be something that I focus in on, and I try to identify, what is the basis that they're combining these references, or what is the basis that they're substituting something in my claim for? And really, as Tony articulated, it's a lot of these, the majority of them, it's all based on these predictable results, and that in turn gives you that ammunition to identify how you go back and how you essentially bring down these premises, how you defend against this obviousness attack, and how you show the weak link in their argument. And I'm sure we'll come back to this list again, but I think it's, as Tony mentioned, this really, they've done a great job with articulating kind of these big picture ways of putting things together. And while, look, this is not a all-inclusive list, there are other rationales to support a conclusion of obviousness, but this is really a good starting point to have a better understanding of kind of the argument that is being used to challenge the patentability or the validity of the patent itself. And so here on this slide, it really just kind of breaks down the prima facie case. And what I thought maybe we'd talk about just first here is I get a lot of questions about, what do we mean by a prima facie case? And so this is from Black's Law Dictionary, but really a prima facie case, just the rote definition, is a party's production of enough evidence to allow the fact trier to infer the fact at issue and rule in the party's favor. And so really here, it's illustrative in that, when the examiner is challenging the patentability of your claims, it's their burden to prove, to establish enough evidence that challenges that claim's subject matter. So that burden of persuasion is on the examiner first. And then it's up to you to then go back and challenge whether they've actually established that burden, whether they've met the burden. And you may go back and, again, look at all the different ways that they've built their argument to challenge it. So if there's no prima facie case established, you don't necessarily need to rebut it, although you may want to consider saying something only because if later on during, you get your application turns into a patent and it's later challenged, you want to have the ability to go back in and, in front of the PTAB and put in a preliminary response that articulates really what the novelty and what the non-obviousness of your claim is.
As a patent owner or a patent applicant, if you can establish that there's no prima facie case, that's usually ideal because you can really go in, you don't have to make an amendment, for example, or present any evidence. You're basically challenging, for example, the examiner or the challenger, if it's an inter-party proceeding. You're basically saying they haven't provided enough evidence to even satisfy this prima facie case test. There's no shifting of a burden over to the applicant. If you can establish that, you're really home free. You've got a very strong position, and presumably you can defeat the challenge that's been placed in front of you.
Right. And now if the prima facie case is established, then really, the ball's essentially in your court at that point in time. You need to come up with some type of evidence to persuade the examiner or the PTAB or the district court that, your claimed invention is non-obvious. And whether that's declarations, whether that's going back in for secondary considerations, again, you have to rebut that prima facie case of obviousness. And as we said earlier, here on this slide, the USPTO's Post-KSR guidelines are really, really instructive, from a patent office perspective, whether it's, the prosecution of your application, whether it's defending against obviousness and post-grant challenges at the PTAB, and then the same thing at the district court or ITC litigation. Again, it's a good primer on how to go back and look at the type of arguments that's being lobbed against you and really challenge those arguments. And from a USPTO patentability determination, it's a preponderance of the evidence that they have to establish. And from the Federal Circuit, when they're looking at district court decisions as well as PTAB decisions, they're looking for substantial evidence, and the legal conclusions are looked at de novo, so essentially fresh.
And it's a little different if you're challenging patents in district court or ITC litigation. There, it's clear and convincing evidence that you need, so it's even more difficult to establish obviousness. In contrast, if you're the patent owner, it's a presumption of validity for your patent, and it's more difficult for a challenger to take it down. It's important to consider that, especially when you look at some of the cases on obviousness, and important to keep that context and framework in mind. And in fact, if you try to cite sometimes an inter-party case that relates to a district court proceeding, the analysis might be slightly different from that in which it is a PTAB decision, for example, relating to an ex-parte prosecution case.
Yeah. So next up, what are some of the ways to defend against an obviousness challenge?
And one of the ways you can do it is just to be careful in how you draft your application. Remember, everything you say about the prior art can and probably will be used against you. So you have to be real careful, especially in your background discussion. We see a lot of applications, especially some that originated from outside the U.S. where there's an extensive discussion of prior art, or possibly an extensive discussion of problems relating to the background. That can sometimes be an issue because some inventions are closely tied to the discovery of a problem, or sometimes a problem is closely tied to its solution. You really have to be careful in just the drafting sense. Also, keep in mind that complexity versus unpredictability, and unpredictability, they can both factor into an obviousness analysis. It's also helpful to keep in mind some basic prosecution skills that we like to emphasize. First, it's important not to paraphrase claim language or to admit that elements are disclosed. That can be harmful if, for example, there's an obviousness analysis or any type of prior art that you're dealing with, and if there's an admission that there is a disclosure. Also, you want to avoid arguing features that are not in the claims. We oftentimes see in the U.S. a lot of foreign applicants that want to emphasize, for example, a problem solution approach. Unfortunately, that isn't often very persuasive to examiners. It's also often not persuasive to argue extensively about some of the advantages of the invention. In fact, that can be harmful if you later litigate your patent. Also, something to be mindful of as well is just be real careful if your client's own patent is cited as a prior art reference. If you make arguments about that patent and your client later decides to litigate that patent to enforce it against another entity, the arguments that you made can and may be used against you in a later proceeding involving that patent.
Yeah, and Tony, I think what this slide reminds me of is that, there's no substitute for good application drafting and good prosecution skills. That regardless of whether it's KSR, whether it's Graham, whether it's some other, seminal case that comes down from the courts, it all really comes back to your drafted application and how you got through the patent office and what arguments you made. And so regardless of what case it is, you should still have a good foundation if you've got a good application and good prosecution skills. And, sometimes that's the best defense against anything else, because a lot of times we just can't read the tea leaves as what's going to be the new hot topic du jour that the courts are going to highlight or focus on for the next couple of years. So up next, responding to an alleged prima facie case by attacking its premise. I think you've probably already, heard us talk about, really going for the heart. What's the argument based on? And I think, one of the best practices here, if you take something away from the webinar today, it really should be, really understand the argument against patentability, whether it's at the PTO, the PTAB, or district court, or ITC, and really understand those references cited against the application or patent, and understand what your claim subject matter is. I think, a lot of times people rush through and they see the examiner cited certain sections in a reference, and really they don't take the time to actually read the entire reference. Why are they cherry picking? Why is the examiner cherry picking or the petitioner cherry picking these little things out of this reference? They really didn't consider the reference entirely and as a whole, and then they also didn't consider my invention as a whole. I think that's probably one of the best ways to defend against, an attack, is really take a look and digest that argument that they're putting forward, because those are when those good nuggets come out. There's no suggestion or motivation to modify or combine. There's no reasonable expectation of success. Look, the reference, even if the references are combined, they don't satisfy all my claim limitations or my claim elements. And, I think, it's a very persuasive argument to say, look, you can put the references together all you want to. You still don't arrive at my claimed invention. You're missing this element X you have yet to find in any of the cited references. And again, attacking that premise that they haven't established a prima facie case, so you don't have to go back and amend, and you don't have to worry about prosecution history estoppel and what you're giving up, but you're just making arguments. That's the best position that you can be in.
Analyzing an obviousness analysis and looking to see whether there are missing claim elements and claim limitations, it's really important to consider claim construction. And keep in mind that for purposes of patent applications and for purposes of PTAB proceedings, the U.S. Patent Office applies the broadest reasonable construction, which sometimes honestly can be the broadest unreasonable construction. They can construe claims incredibly broad, and this oftentimes trips us up because examiners can be very creative in how broadly they construe claims. Similarly, we often find that examiners can take pretty creative interpretations of prior art and broadly construe the prior art. It's always important to keep that context in mind and to keep that framework in mind and to get a better understanding of exactly how the examiner is interpreting the claim language and interpreting the prior art, and to get a better assessment as to whether you might have a good argument that in fact a particular claim element or claim limitation is not satisfied. It's important also to look for example, at functional language in the claim. Did an examiner just completely ignore it? Can you possibly strengthen the claim a little bit through an amendment? That's also something you should consider because it's another aspect that you have in your toolbox. Can you possibly make an amendment, possibly just to maybe give some patentable weight to subject matter, be it functional language or other language, and can that really strengthen your position against an obviousness rejection? Of course, it really depends on the forum that you're in. If you have an application and if it's at a particular stage where you're free to amend, you're able to do that. If it's after final or if it's an appeal, you might have options that are much more limited. Similarly, if you're in a PTAB proceeding, it's very limited, and it's certainly limited if you're in district court litigation or ITC litigation. But really important to consider what tools you have and what's an effective means by which you can challenge an obviousness rejection, and this is another aspect to consider. Have all the claim elements been satisfied, and can you possibly change the game a little bit and amend the claims?
So from a mechanical perspective, Tony, when you do add another element and you're going back and forth with the examiner, do you find that depending on kind of what that element went to, that examiners often then just come back and cite another secondary reference, or are they more apt to then conduct another search and give you a different set of references that are relied upon? Do you see a pattern, or do you see any?
Oftentimes, I think it really depends. It depends on whether you can create some comfort in the examiner. And one technique that we really emphasize with our clients is to try to establish sort of an open communication, to go in and have an interview with an examiner. Oftentimes you can go in with a claim amendment proposal. If you can get the examiner to possibly commit or to acknowledge, it can really streamline the process. It can make it much more efficient. You can find out what you need. Oftentimes the examiners will update their searches and look a little further. Sometimes they will find features, but I think if you can come to at least a preliminary agreement with an examiner, it can really greatly increase your odds of having success. Of course, the way the examination process is structured, and I was an examiner, by the way, over 24 years ago before I started Finnegan, so this is eons ago, but I still remember it. They are faced with some pretty significant time constraints, so they don't have all the time in the world to just change around rejections and just keep rejecting. But sometimes there are practical constraints where they, for example, might be under a strict evaluation because they're trying to advance in the patent office and their work is being scrutinized closely. But usually if you can come to that agreement with the examiners, it can really streamline the process.
Yeah, and I'm really glad you brought up examiner interviews, because I really think that's one of the tools that we have at our disposal to really get a better understanding of what really is bothering the examiner. And those claim amendments, maybe adding that additional claim element after the examiner interview, wins the day, because you've already talked about it, you understand his position or her position, and you've discussed the amendment, and that gives them a lot more ease at allowing or granting the application. And granted, they may conduct another search, but they have a good understanding of what's out there to begin with. So I do think having that examiner interview and really just coming to the table with, okay, look, what is the issue? What hurdles do we need to overcome? And in some instances, what's actually down on paper isn't really what is bothering the examiner. What we think, the issue is based on reading the office action, and really what it is when you talk to the examiner could be two different things. So I think, having that, whether it's a face-to-face meeting, whether it's a teleconference, what have you, is really helpful to, overcoming those issues or those hurdles or those roadblocks that are in your way that, may not be abundantly clear just looking at the written record in the office action itself. So next up here, on this next slide, again, we're taking a look at what are those ways to evaluate your obviousness argument and ways to overcome it. We talked a little bit about unexpected benefit or result, looking and identifying in references and cited art, is there a teaching away, or is there some other way to make the distinction between the claimed invention and the cited prior art? The other thing is, are there so many different possibilities that, we're not just choosing from a finite number, we're actually talking about a very large number of possibilities, which then, further stretch us from an obviousness conclusion. When you've got, thousands upon thousands of choices, that's a far cry from a handful or a dozen different options that a person of ordinary skill in the art would have to choose from. And again, as we discussed earlier on, KSR really addressed that motivation. And so, taking a look at what that motivation was to put the different references together is instructive. I will say from a chemical pharmaceutical perspective, a lot of times we like to argue this lead compound rationale. Is there a reasoned identification of a lead candidate compound in the prior art? It has to be something more than an unsupported assertion made by the examiner. How and why would a person of ordinary skill in the art have picked, a starting point, a starting compound, and then proceeded with modifying and combining? And then, how would they have a reasonable expectation of success? And challenging those lead compound rationales has really been helpful and successful in getting cases granted. I think other ways to combat, obviousness is, does the proposed modification, does it render the prior art unsatisfactory for its intended purpose? The same thing is, is the modification that's being put forward by the examiner, does it change the way the cited art works? Is the examiner just really taking this alleged benefit from a prior art reference and just, taking it out of its context and trying to put it with all this other stuff? But by doing so, the examiner failed to appreciate all the other stuff that was necessary for this benefit to actually happen. So I think there's multiple different ways to look at the obviousness argument and try to bring it down or try to, attack its premise that we've been talking about so far. This next slide, again, other considerations when you're looking at your obviousness. Again, the Graham factors continue to be the basic test for obviousness. Again, you still need to have a reasonable expectation of success when you're combining different things together. This next bullet point, too many variables. You have got multiple choices, unpredictable results, multiple different types of properties. One of the ways that I used to structure a lot of my challenges to obviousness is really, just going through stepwise and articulating, and however many steps it took, how many steps it actually took to get you to my claimed invention, based on the examiner's logic that they've put forward. And a lot of times I would put that back in my response, and there was 15 different steps that the examiner was saying were obvious to do, but yet to have them spelled out in 15 different ways, it really showed that this wasn't as obvious as the examiner was alleging, that it took multiple different ways and multiple different choices to really arrive at the claimed invention. A lot of times the prior art only gives us some general guidance how to achieve an invention. I think that particular bullet point really goes to kind of a genus-species argument that I think is probably more prevalent in the chem, bio, pharma space than in the mechanical space, but really going through and saying, look, the prior art may disclose the genus, but my species compound, is in amongst thousands and thousands of different compounds, and going through and, showing the size of the genus, what the expressed teachings are, if there's any structural similarities or structural dissimilarities, the differences, the predictability. Again, those are good ways to challenge obviousness. I always, if you have it, it's great. But teaching away, I think everybody would like to have, at least from the chem bio side, a teaching away, because that really tends to be something the examiners tend to pay attention to, at least in Tech Center 1600.
And just in terms of the unpredictability issue and predictability issue, of course, that is, I think, more a factor in certain types of arts, and it can be established in certain types of arts. And as we mentioned before, the chem, pharma arts, it's more common. It's not as common in the electrical and mechanical arts. With regard to rebuttal evidence, we talked about how you can basically submit evidence to refute an obviousness finding, to challenge a prima facie case. One thing that's real important to keep in mind is that especially with regard to secondary consideration evidence. The Patent Office is really strict, and courts are really strict on looking to see whether there's an adequate nexus that they refer to as the link between the evidence that you're presenting and the scope of the claim. And it's real important to have that link and to establish it. And we find that oftentimes you're seeing evidence that's submitted in real important cases, for example, cases that maybe have been pending for a long time, PTAB cases. It's really important to do that. And now we'll sort of shift gears and talk a little bit more about secondary consideration evidence.
Yeah, no, I mean, I agree with you. The secondary considerations, whether it's commercial success, unexpected results, long-felt need, skepticism, praise, failure, evidence of copying, those are good. It's good evidence to have. From the chem pharma side, we tend not to have those types of secondary considerations, but what we tend to have, as Tony was articulating, is really those unexpected results, and really tying those unexpected results with, what we have claimed. And I think we've seen from the courts that, it's really becoming very difficult, and they really look at and challenge some of those secondary considerations and really that nexus between the claimed results and, that secondary consideration. So it is a difficult standard to meet. And then up next, what roles do unpredictability and unexpectedness play, especially with regard to particular technologies? I think we've touched on some of this already, but again, unexpected results tends to be something we have in the chem pharma area, and a lot of times if we have it as we're drafting the application, by all means, all of that good stuff needs to be put in the application. And I think what we've seen from courts recently with unexpected results is that, most likely you are going to be challenged on it. And so it really needs to be unexpected. It needs to be an indicator of non-obviousness, because we've seen some courts, really find that it's not meaningful or it has little weight. But you do, if you have it, it's more than additive and you're able to show it, by all means, that's something that you can rely upon. But again, it really needs to have statistical and practical significance, and it's on the burden's on the applicant to establish that those results are in fact unexpected and unobvious. And a lot of times this stuff comes in through a declaration. The unexpected results usually is in the form of a declaration, and a lot of times it's very easy for the examiner to come back and say, look, it's not commensurate in scope with the scope of claims you're seeking. So when you're doing a declaration, when you're putting unexpected results forward, you really need to look at what you're putting forward. Is it commensurate in scope? Does it really show that nexus between my claimed invention and that benefit? And again, is it, have I tested enough? Did I test everything, the closest prior art, et cetera? Unpredictability, I think we touched on this earlier, that a lot of these exemplary rationales really find root in predictable results. And if you're able to show unpredictability, some of that falls to the wayside. But with unpredictability, you really need to be able, it can't just be attorney argument. You really need to show in the art, whether it's in those same cited references or other references that you bring to the examiner's attention, to show that it is unpredictability. There's unpredictability with respect to the combinations, with respect to the results, with respect to how this is looked at in the art. And I think in this next slide, if the examiner rejects a claim as obvious to try in light of the prior art, the examiner has to identify that there's been a finite number of identified and predictable solutions, as well as that the inventor or person of ordinary skill in the art could have pursued these solutions with a reasonable expectation of success. And a lot of times we'll like to argue both of those two parameters, the number of identified predictable solutions, as well as there isn't necessarily a reasonable expectation of success. And you'll see that a lot of times I would much rather argue unpredictability than unexpectedness, only because I think unexpectedness is difficult for an examiner to swallow, and I feel like we'd have to submit a lot of times multiple different iterations of declarations, and I tend to shy away from using declaration evidence just because I know how hotly contested it can be during litigation.
And I have to admit, in mechanical and electrical cases, I would hate to be relying on solely an argument of unexpected results or predictability. But I have relied on that finite number of identified predictable solutions. If you can expand the universe and show all the possible variables, you can really sometimes make a really strong case of non-obviousness.
Yeah, agreed. Agreed. Again, with unpredictability, it's, obvious to dry is not obviousness. You need to, again, go through, the examiner needs to go through the rubric there. And again, unpredictability tends to be, something that I often argue in cases. And then the other thing I just wanted to bring up here with respect to unpredictability and unexpectedness is a lot of times in the chem and the pharma space we've seen recently that we're seeing inherency playing a role in obviousness analysis. And in the 2010s, we've had a huge uptick in inherent obviousness compared with any other time period. And, inherency may supply a missing claim element in an obviousness analysis, but it's, really narrowly circumscribed when applied to an obviousness context, and it's really highly factually dependent. And, unexpected results or benefits are typically not something that's inherently obvious. However, we've seen a lot of applicants try to essentially claim measurements or functional limitations, and in those instances, that's where we see this inherent obviousness kind of playing out. When and where to use declarations, and I believe this is our last topic here for the webinar. And here are declarations. I think we kind of touched on some of this earlier, but when you're submitting a declaration, an expert declaration, you need to make sure that you've put enough information that the patent office can find that it has value. So, for example, you need to make sure if there's any bias, whether the expert has been employed by the assignee or hired by the assignee. You need to establish the qualifications, establish the factual basis for the conclusions. And you want to make sure that the evidence that you're putting forward is the claimed invention is compared with the closest subject matter that exists in the prior art. And a lot of times, this is in some instances difficult to do only because it takes a while for declarations for the data to get run, at least from the chem pharma side. And a lot of times what the examiner comes back after you've put in the declaration, the examiner comes back and says, look, you haven't compared it against the closest, prior art. And in the examiner's mind, the closest prior art is the combination of the prior art that's being cited against you. And I've gotten in many battles with examiners about what the closest prior art is, and I keep telling them, look, I'm not going to compare it against the combination of references that you've cited against me. If I do that, it's my claimed invention against my claimed invention. That's not what that serves no purpose. If there's a single prior art reference, I will, put the comparison with that single prior art reference, but I'm under no obligation to compare the prior art, a combined prior art against my claimed invention. So again, you need to be careful. Declarations are typically used to show unexpected or superior properties. Again, maybe secondary considerations. Again, I tend not to have any of that evidence, because usually we're very early in filing and that stuff hasn't worked its way out, but unexpected or superior properties. And then the last one, maybe I'm putting in a declaration about the state of the art. Again, I will say that I tend to be very cautious in declarations and I tend not to use them, but it may be you're up against the wall and you really do need to put, you need to rely upon a declaration. And again, maybe it's to really shore up your non-obviousness argument. And in some instances, it's very helpful to do it during prosecution because later during a PTAB proceeding, it can be instructive and helpful when you put in your petitioner's or your preliminary response, your patent owner's response. But again, there have been instances where the declaration has been turned against the applicant and is used for a different purpose. So with that, I think we'll just conclude the discussion portion of the webinar, and I believe that we may have some questions that we can go through.
Great. Thank you, Adriana, and thank you, Tony. We do have some questions, but before we begin the question and answer portion of our event, please take a moment to complete our brief evaluation survey. Because we continually try to improve our programs, we would appreciate your input, which will guide us in planning future programs. It is now time to address questions from those of you that are attending. As a reminder, to participate in the Q&A, just click on the Q&A button and type your question into the Q&A window and then click Submit. For those questions that we can't get to today, we'll try to get back to you after the webinar sometime later this week. So the first question we have, I'll just read the question directly as we receive them. And the question starts, I often get obviousness brought up again with a second set of references after addressing a first objection to a first set of references. It is as if the examiner just keeps on doing searches throughout prosecution. Can you discuss if the examiner is allowed to do this? Clients find this particularly difficult to stomach when they thought they have overcome everything after 2 or 3 OAs and then further material is brought in. Tony, do you want to take the lead on this one?
Certainly, and that's a very good question because this is a real headache for many of us, for those that are practitioners and for clients. It can sometimes go to no end that examiners just continue to reject in obviousness rejections. And they are permitted, in fact, to continue to apply different art, but there are some constraints they have. There are practical constraints. They can have difficulty, for example, making an office action final if there has been no amendment that necessitated the finality. There are also internal credits that examiners get, and they have severe disincentives, really, to continue to play these types of games. And as we mentioned before, another technique to keep in mind is consider interviewing the case. Maybe there's some reason the examiner is refusing to allow it. Maybe the supervisor is the one calling the shots, and the examiner is just a poor junior examiner that's just forced to just continue to reject. Oftentimes, though, if you talk to the examiner, have the attorney talk to the examiner, find out what's going on, it can really help quite a bit.
Yeah, and I would also add there, Tony, that doing the examiner interview and really the patent office has tried to give the examiners counts and the value of those counts early in prosecution such that they don't do this. They give them more counts in the beginning to do a good search and a good examination, and any of those subsequent office actions that they have to issue, diminish in value as you go on. And in some instances that works. In other instances, we've seen that, the examiner just continues to do a search or all of a sudden adds a new reference, but essentially sticks with that same combination of references. And so it is frustrating to get another office action, but I do think, giving the examiner a call and figuring out really what the rationale behind it is really helpful and instructive.
Great. The second question we have is how to tackle obviousness objections when USPTO examiners cherry-pick features from secondary references and forcefully combine with the primary references. Adriana, do you want to take the lead on this one?
Sure. I can't tell you how many times this has happened to me and continues to happen to me to this day, that examiners love to cherry pick references, particularly the secondary references. And it's very easy for them to do. They just essentially cut and paste it into the office action. But my response and how you get around that stuff tends to be a lot more arduous to put down on paper, meaning, to show them that they are cherry picking the reference, you really have to read the entire reference and give them the reason why they can't just cherry pick from that laundry list that they're choosing it from, why it just doesn't work as simply as they've put forward. And again, looking back at that one slide where we have all those example rationales, maybe you can find one of those rationales to attack that you may be able to find, in multiple different secondary references, this claim element, but we've put forward this claim element in a different manner. Or when you cherry pick that claim element from that reference, you're essentially changing the way that reference, how that reference works, that you can't just cherry pick it. You actually have to cherry pick all the other stuff that comes with that reference. And in fact, we're contrary to that. So it's really taking a look at where the examiner is cherry picking from and how it fits in with all the other elements. But it tends to be a very lengthy argument to make. And again, having a discussion with the examiner, discussing that rationale with them prior to filing the response, getting their take on, your arguments is helpful during an examiner interview.
Great. Well, I see that we have just passed the scheduled end time for our webinar today, so I think that's all the questions we can address during the webinar. Thanks to everybody for submitting your questions. And thank you for attending today's webcast, Obviousness, How to Prove and How to Attack. This presentation will be available on demand in the next week. Please look for an email from us with the access link. This concludes today's Finnegan webcast. Thank you for participating.